Hello everyone, I'm Sharon Abaud, immigration attorney, here to talk to you about how to know if, let's say you're filing through your I-130 family-based petition and you're living in the United States and you want to know if you get to apply for adjustment of status or if you have to leave the country to obtain your green card. We're going to talk about that. Stay tuned. Before I get started, I want to remind you to please subscribe to my channel and click the bell so that you receive notifications every time I have some new content for you. And please keep in mind that all the information I provide is just that. It's just general information. I'm not giving you particular advice for your case. Always, always, always seek the advice of an immigration attorney for your case. And obviously, you're always welcome to call me. You can call me at 310-803-3040 to schedule your appointment with me. Now, let's say you have a family-based petition for you and you want to know, do I qualify to adjust my status so that I don't have to go to the interview abroad? Going to the interview abroad has a lot of negative, it's always better to adjust status if you can. Going abroad entails it's a lot riskier, okay? You're going to an interview where you can get denied and you just don't have as many rights abroad as you do here. It's costlier and it's also a longer process typically. Aside from the process being longer, it can be, there's no work permit in between, nothing. So, you're just kind of, you get nothing in between. Whereas when you qualify for adjustment of status, you at least get some sort of work permit, travel permit while your case is pending. Okay, so now that we have cleared that out of the way, let's find out if perhaps you qualify for adjustment of status. So the first question is, some of the ways that you can qualify for adjustment of status, let's talk about the first one, would be through a lawful entry. If you entered with inspection, so that can cover different types of way you entered, but you entered with inspection, that can even count if you, let's say, were waved in at the land border and maybe you don't have a stamp in your passport, or maybe you didn't even have valid documents at the time, you were just waved in, they let you in, that could count as an inspection. The tricky part is proving it, but I've been able to prove that before. That's just, on a case-by-case basis. We can use different forms of evidence to prove that you entered that way. If you're successful in proving that you entered through a wave-in, then you would be able to adjust your status. However, when you enter lawfully, when you enter with inspection and you're basing your adjustment of status application through that way, it is important to ask who is filing for you. So if your family-based petition is based on a U.S. citizen spouse or a U.S. citizen child, if a U.S. citizen spouse or a U.S. citizen child filed a petition for you, that means that you can adjust status even if you overstayed your tourist visa, even if you never really had status, you just were waved in. Your current status will be irrelevant if you entered with inspection, but only if you are immigrating through an immediate relative. If you are immigrating, say, through a resident spouse or a U.S. citizen sibling, for example, or maybe you're the adult child of a citizen, then you are not considered an immediate relative. And if you entered with inspection and you overstayed the amount allowed, then you will not be allowed to adjust your status. So, it can be a little tricky, so that it's things like this where it's always important to consult with a professional to make sure that you make the right decisions for your case. The second way that you may qualify to adjust your status is under 245I. A lot of people who have 245I walk into my office with that golden ticket and they know they have it, but some people don't know they have it. So if you were the direct principal of a petition, then likely you know that someone filed for you on April 30th, 2001 or before. So I'll repeat. If someone filed a petition for you on the 30th of April of 2001 or before through family or employment, you may have 245I. Okay, there's a lot of caveats, so I'm saying may. Who also may have 245I, if you were the minor child of the beneficiary, you might have it too. And it depends on your age at the time that it was filed, and even if you were the spouse at the time. So you might be divorced now from that person, but back then when it was filed, you were married and you qualified as a beneficiary of that petition, you might have your own 245I. So these are important things you need to bring up in your interview, okay? Because it might change the course of your way to immigrate. If you qualify to adjust status under 245I, then you may qualify, you can adjust status even though you entered without inspection or overstayed or have unlawful presence. Mind you, entries and exits are still an issue, so I'm not talking about that. I'm only talking about whether you may qualify. There's a lot of other issues in the background that can come up, so always, please consult with a professional before making any big decisions on your case. Another way you may qualify to adjust status is if you have TPS. Now this is only in some states, such as California. Not all states allow it, but for example, in California, if you have TPS, it may be considered that you have an admission that qualifies for adjustment of status. Another way that you may qualify for adjustment of status and not have to leave the country would be if you have some form of advanced parole. So again, maybe you had TPS and you applied for advanced parole or a travel permit and you left the country and you came back with that travel permit. That could count as your way to be able to adjust status. And this goes for people with DACA as well. So if you have DACA and you qualify for advanced parole, then you may be able to request advanced parole and then leave the country briefly and return with it, and then that could be your admission for adjustment of status. Now, a little side note, who qualifies for the DACA advanced parole? So if you have DACA, you may qualify if you have one of the 3 reasons to leave the country. Humanitarian reasons, so for example, maybe you have a sick family member abroad. Educational reasons, maybe there's a course you want to take abroad. Or business reasons, so maybe you have to go to a business meeting, or maybe you need to sell some property. These would be reasons that would qualify under DACA. Another way that you may qualify to adjust status is if you immigrate through the U visa. So I've talked about this in other videos, but a U visa is for victims of crime. So if you were the victim of a violent crime and you cooperate, and I'm being very vague here, but if you were the victim of a violent crime that occurred in the United States and you cooperated with law enforcement, you may qualify for a U visa. And if you qualify, I do want to say it is a long route to take, but for many it's still a great option if you have no other way to immigrate, or if you have, for example, a perm bar because of your entries and exits, or maybe you made a false claim to U.S. citizenship, which disqualifies you to immigrate through family. So, if you're immigrating through a U visa, after 3 years with the U visa, you may qualify for a green card, okay? And when you apply for residency, you wouldn't have to leave the country. You would be able to do everything here. Another way you might qualify to immigrate in the United States without having to leave the country would be under VAWA. Okay, so if you're married to a U.S. citizen or a resident and you are suffering certain abuses or certain mistreatments, extreme cruelty is the standard, but I do want to emphasize that you do not necessarily have to be, the abuse does not have to be physical, okay? It comes in many forms. So if you think you qualify, it's really important that you call me, schedule a consultation, and let's talk in detail about your case and see if you have a VAWA case, because if you do have a VAWA case, then you may qualify to apply for adjustment of status. You'd be able to get your green card without having to leave the country. Not everyone under VAWA will qualify. Obviously, it's not as forgiving as the U visa. So if you have something like a false claim to U.S. citizenship, for example, you might get the VAWA, but you won't get residency. So these are important things to note. Now, I mentioned some of the ways that you would be able to adjust status in the United States. What happens if you have to leave the country? What if none of those apply to you and you have to leave the country, but you have this I-130 petition that your U.S. citizen spouse filed for you? Well then, assuming there's no other grounds of inadmissibility, then you would need to file a waiver for unlawful presence. Now I'm talking to people who are living in the U.S. I'm not talking to people abroad or anything like that. I'm talking to people who are in the United States. If you're in the United States, before going to an interview, you would want to file a provisional waiver for unlawful presence. And that waiver would be based on the hardship of your U.S. citizen or resident spouse, or even your U.S. citizen or resident parent, okay? If you win that case, that waiver, once that's approved, then we would set you up for your interview abroad, which could take some time as well. But the idea is that you would leave to your interview, instead of leaving for years, you would leave for a few weeks. If all goes well, you come back, and once you pass inspection, you would be considered a lawful permanent resident. Again, if you have to go that route, you would not have a work permit in the meantime. You wouldn't have any of that. So, that's why it's always important to try to see first if there's a way to adjust. I always try to see if there's a way to adjust my clients, and obviously know that there may be another alternative, even if it means having to leave the country. I'm Sharon Abaud, immigration attorney. Really excited to be here with you. Just wanted to remind you to go ahead and subscribe to my channel. Don't forget to click the bell to receive notification every time I have new content for you. And please share this video. And if you want to talk to me personally about your case, please call me at 310-803-3040 to schedule your consultation. Bye-bye.